back to 25% of the actual timber receipts, which comes from cattle grazing and timber receipts. And so, I mean, if we had that number, we would know what proportion of the monies that Lassen County and the different schools would be getting, which I think is huge.
I
can
at least contact some of them and see if they can help me out with that, sure.
And I agree, you know, that like Jeff just said, you know, this is it's a huge undertaking on your part, and I greatly appreciate it. And a lot of people don't realize that this information here goes back to the federal government and the USDA, that the RCS and FSA to help with the drought assistance, and except for a lot of farmers really rely on. And this takes a lot of work, and I commend you for doing it, because I know Mohawk County doesn't do it. And he's our ag commissioner, and you guys took it upon yourself to do it. And,
correct.
And thank you. It's well done and thought out. It takes a lot of work. And thank you.
Well, thank you.
Absolutely. Thank you, Sheriff.
Thank you.
Thank you.
Thanks for the information.
We'll move on to page 3. This is looks like a possibility, but I don't think it is.
Mr. Chairman, I've asked Ms. Skeen to present these issues on behalf of the Office of County Council, and with further ado, Ms. Skeen.
Good morning, Mr. Chairman and Board. Deputy County Council Stephanie Skeen. The Government Code and FPPC regulations require that each county have a current conflict of interest code. Here in Lassen County, we have a single code, like most counties do in California, that incorporates all of our departments. Specifically to your duties under the code, the Government Code establishes that the Board of Supervisors is the code reviewing body for purposes of review, and no code can be utilized until you have approved it. So you have 3 options when a code does come before you under the Government Code. One option is to approve the code as you have it, to amend the code and then approve it, or to return it with required revisions. So as stated earlier, Lassen County does have a single code that incorporates all departments, and this code is regularly updated annually. So those updates are typically revisions in titles, new positions added, new disclosure categories, review of delegation of duties, deletion of positions, and just an overall review of the law to make sure that the current law is being utilized. So what you have in front of you is a list of the substantive changes to the 2014 code that you all passed last year. And you also have the proposed 2015 Lassen County Conflict of Interest Code. And I'd be happy to take any questions on it. Otherwise, I would, as council, propose that you approve this code by adopting the resolution.
Question 2.
I have several, Mr. Chairman, and I'm not quite sure because they all kind of interrelate with each other, so they'll probably be kind of grouped together. But to start with, on the very first one, I noticed it's on, this is H3, it's the second sheet. I guess these are the amendments that you're proposing to be incorporated by the action for Appendix A. And it shows on the top of the second page you have appointed boards and commissions, and you're showing alcohol and drug advisory board add 1, 2, 3, 4, and 6, and Highway 36 Town Health Safety Task Force add 1, 2, 3, 4, and 6. So my question is, are we adding these or deleting these?
These are being added. They were
excluded. The reason why I'm questioning that is the Highway 36 Town Health Safety Task Force met, it was established and met back in 2006 and 2007 in a very active fashion, came up with its report. It met annually for about 3 or 4 years after that to review the implementation to make sure that it doesn't collect too deeply on the report. But since about 2011, it was disbanded and basically does not function or exist anymore. And so adding something that doesn't exist doesn't make sense. And then even though there's references made to that report, you know, on an ongoing basis, the group that's involved there hasn't formally met for a good 4 or 5 years now. And then the Alcohol and Drug Advisory Board, my understanding was basically discontinued along with the Mental Health Advisory Board, and they formed the new Behavioral Health Board which is on the list, but mental health board isn't on the list anymore because it was disbanded along with the alcohol. They were kind of merged into one board, and it's kind of the new name. So why would we be adding the name of a non-existent board that's been merged into a different board that's on the list?
Well, as far as the Alcohol and Drug Advisory Board, I believe on last year's, the reasons these two were added is because they didn't appear on last year's, but the information that was given
And the
to
reason
me-
why they didn't appear on last year's is because they had been discontinued previous to that time, so there would be no need to have them on last year's. So in essence, we're resurrecting two boards that don't exist anymore, is what I see. And that's the reason why I question that.
Well, I understand your question. What is provided to me is the current list of boards that we do have that are still being referenced to, and I added those back in because they weren't on last year's. I do understand why you're saying they weren't on last
Well,
year's.
whatever list that is referencing needs to be updated to reflect the fact that they don't exist anymore.
Okay, I respect that. I just have to add whatever is listed as our current
Is this
boards.
coming off of Susan's, your
Yeah, we did have an issue with the formatting from the old form, and we had a huge issue on the formatting, and I think this is a problem on this one. These two should not be on the current one.
exactly.
But we did have,
Because I think 2 or 3 years ago,
Yeah.
we had a discussion about the, drug and alcohol was being merged in, so that one was easy, but,
Yeah.
the Highway
No, I
36
think-
was still
yeah.
existing out there, but they hadn't met for 2 or 3 years and wasn't planning on meeting.
no, I think it's a problem coming from my computer
Okay.
being changed over to Regina's,
Well,
and we had some
My
issues with the
recommendation
formatting.
is that we get that computer problem resolved and fixed, and we don't complicate the code by adding these two back in. So I would recommend that we not do that on that one. And then, could you, on amendment to category 2, I mean, kind of like a huge paragraph, and I read it, and I get about halfway through it, and I get lost, and about 2/3 of the way through it, I get like a headache. And trying to understand. I mean, I realize there's some significance here, and I don't have the well-trained mind that you have to read through this. So, in like plain English, could you tell me what it's trying to tell me? It says that if you have an investment of $2,000 or more, you have to disclose it in this category. If you're charged to do so in category 2.
Oh, in category 2, which is in appendix B to the resolution,
Right.
the only thing that is changed is there's a few words that are crossed out there. I just have a strike through there. That's changed for the updated code because the trusts that are created in accordance with the code that was listed, that code has been repealed, so those trusts can no longer be created in accordance with that code. So the language just changed in the code that was cited as Government Code Section 82034. So I just changed the language to
Make it
be exactly.
consistent, and that's always marketing. I understand common stock, preferred stock, and those kind of stock, but beyond that, if somebody was putting together a partnership and you decide to invest in the partnership and it's $2,000 or more, even though it's not stock, you just throw money into a pot, let's say, that has to be disclosed in there.
Yes, absolutely.
So, I just want to make sure that I'm not reading it wrong, because there's so many avenues. And then the other thing is on amendment to category 5, which is dealing with gifts. And that's also, according to this, is because the Fair Political Practice Commission is now up the threshold for disclosing of gift costs. And I remember at one time it used to be like $50, but anyway, it's up to $460. And the reason why I asked that question is when we get through the rest of these, especially the ones that deal with the schools and stuff, there's several references to dealing with the gift part of it, but the dollar amounts vary. And some of them go up to $460, some of them are $320, some of them are the current rate, which apparently was in there at $360. So they're kind of like all over the map. So it might be good to go back through and make sure that they are all reconciled to be what the current amount under the FPPC guidelines are. So making it all consistent. So everybody is using 460.
Okay, the districts are a slightly different review on behalf of the council's office. I changed ours to match exactly what, or the proposed change is to match exactly what the FPPC guidelines are. The districts set their own limits.
Well, since we're the review body, Okay, they're obviously doing their own thing because they're thinking they're doing what everybody else is doing. And I think from the perspective of the general public, it would be, the public interest would be best served if we used across the board the same, so there's no confusion. Well, you're on a board that only does 320, you're on a board that does 360, but I'm on a board that can do 460 in terms of value. And I think that that opens up a huge problem in terms of, you know, people's perception in terms of what the official conduct is, the level is. And since the FPPC has standardized that at 460, I think it would make sense that we adhere to whatever their rate. And maybe the way you word all these isn't so much by putting in a dollar amount that you have to update, is to use the wording saying that whatever is the, it's kind of like what we do with the IRS on the reimbursement for mileage. Instead of saying what necessarily the mileage is in each of the different organic resolutions, it's whatever is the current standard for, you know, set by the IRS and whatever the rulemaking process is. And that changes. It could change 3 times in the course of a year. I mean, it's up high now because of the high gas prices, but now gas prices have fallen down. They may revise it downward because of that. And so, you know, you don't want to go back and change your resolutions and stuff, you know, every time there's a fluctuation. And so I think that's something that should be looked at. And I would like to see it, if we could, from an administrative review process. That's what we're doing here today, is to make those all standardized if we could. Because I thought that was kind of odd that there's some other boards that are $320 is their limit, and other boards have $360. And we were $360. We're now going to $460 under this proposal. So just for what it's worth. And one to look at as an example, and they're not just school districts. This is the Hallelujah Junction Fire Protection District. They're the one, they're using 320, which is probably kind of an older version. Somehow they're operating off of an older version. But what's also interesting, and you can answer this question maybe, is when you get to the school district ones in particular, but we have 6 disclosure categories, and the 6th disclosure category is the gift rule. But when you get to the school districts, they only have 5 categories. The 6th one doesn't exist. There's no rule there. And they've got, I guess maybe, do they operate under the Ed Code under a different setup? I mean, does anybody know?
They have the same obligations and requirements. If you'd like me to switch to talking about the districts, I can do that, which is items each 5 through 9, 4 through 9.
Well, 3 and 4 is what we have before us now, and that was where I saw the 3.
I'm sorry, Mr. Chapman. Actually, only 3 was called, and 3 is simply the county's version of the conflict of interest code. And Ms. Keene and I spoke about this before we came today. H3 is kind of one issue and one function of this board, and that is to deal with its own employees and its own conflict of interest code, whereas H4 through 9 is a second and separate function and could collectively be dealt with. But it is separate. That's the code reviewing function.
Well, the template's going to be the county code. That's the one we're dealing with right now. And so I've got the answer to those 2 questions.
Let's get it to county. Do you have any more discussion on county being H3? Jim, do you want to make a motion? Or?
Yeah, I would make a motion that we approve the update to the county code, the amendments to appendix A and B, with the proviso that the Alcohol and Drug Advisory Board and the Highway 36 Town Health Safety Task Force not be added.
Okay, is there a second to that?
I'll second that.
Okay, discussion. Public, Mrs. Spencer, do you have a comment? Come to the podium.
The document before you is terribly flawed because most of the positions that are listed either don't exist or they're listed incorrectly. We have a handout in a second. The Lassen County Ordinance List chronicles changes the Board of Supervisors have made over the past 79 years. And I have a copy of it here if anybody even cares or even knows about it. The Lassen County codes should support the ordinances, but they don't. the two documents are in conflict. And that is how you prepare the document that's before you. You have to have real positions that have been approved either through an ordinance or resolution. This document is fairly flawed. And if you pass it, then I have to question whether or not you even care about the law that governs this. Ordinance 441 is Lassen County Code Title 2, Chapter 2.08, 030, and 2.8003 state that the county council serves as the attorney for the public administrator, but Lassen County Code Title 2.09 consolidates the district attorney with the public administrator. This change was mandated by Government Code 24300. Lassen County Code was never updated on that. So you have a conflict between Mr. Burns' position and the district attorney's position as far as preparing this document. It just simply needs to be corrected. Ordinance 473B, in 1997, this ordinance created, not amended, the position of county administrative office. Lassen County Code Title 2, Chapter 2.06.010 and 2.6015 state that a new position has been created. Ordinance 531, the conflict of interest does not, your conflict of interest report does not list the clerk of the board. This position is mandated under Government Code 251 and 268001, excuse me. You have budgeted this item clearly identifying the clerk of the board as a position under government codes. This is from your current budget.
If you can speed it up, we're running out of time.
Sure. I don't think you care anyway. But, I'm not even going to read that. But this handout will be posted in the on our website. It basically states that you're not treating the clerk of the board according to law, and it gives you what the law states the clerk of the board should be, and we recommend that for the efficiency of this position, that the clerk of the board be moved back in as a separate position within the authority of the CAO, be supervised by the CAO, Mr. Egan, and properly place the Board of Supervisors minutes on the agenda as a standalone item under the heading Clerk of the Board. So all we're asking is that you follow the law.
Thank you for your comment, Jim.
Mr. Chairman, comment. I think Mrs. Spencer is confusing our department head structure with our budget units. And what she handed out here, what we just received as handout, identified for the record however you want to, County Council, is the breakdown of the various budget units within the county budget. And the county clerk recorder, which is a department, an elected department, administers and oversees 4 different budget units, one of them being the clerk of the board, the other one being the county clerk's function, and then she has the election function and the recorder function. And, you know, when a department heading is put into the agenda and references are made, it should be based upon the department, which in this case is the county clerk/recorder. We don't have a separate department called clerk of the board. The clerk of the board function is assigned to the county clerk recorder to provide to this board and to the county. And I think that's the clarification that should be made. I know she's insistent on wanting to perform the functions of administration for this board, but she hasn't been hired by this board. And I think her presentation is not in order.
Any more discussion on H3 before we vote? Seeing none, we'll vote on H3. All in favor, say aye.
Aye.
Opposed, say no. Ayes have it. Now, I think we can take a motion, 4, 5, 6, 7, and 8, and 9. Can you do that, Council?
Well, I think, again, Ms. Keen,
If you guys don't want to, I can give you the opinion to heat it up, but if you want to take it one at a time, that's it.
Well, there's two different things, and I think, the first two on 3, I mean, 4 and 5 are dealing with, you have Elmwood, Honey Lake RCD, and the Hallelujah Junction fire districts, which are non-school related type functions, so that's the ones where, and then you have all the school ones that are combined together from 6 and 7, 8, the ones that are dealing with there. And what? Well, I have some specific questions as to why the different, the inconsistency in the standards, because they're showing in the, like the districts have only 5, well, some districts have 5 categories and others have 6. And on the one for Hallelujah Junction, there's 6 categories. They actually reverse 5 and 6 as it relates to what the county's disclosure category is. So, when you talk about category 5, I think whether it's at the school level, at the district level, at the county level, you would want to make sure category 5 is talking about the same expectations, because the general public out there isn't going to have the appreciation of the nuances of what the various categories are. And I think the one that is probably the biggest one that people are interested in is the gift limits and levels. And that's where under this particular one, it's H4, category 6 is the gift limit, and category 5 is your involvement as a business position with a business entity. But that's just the opposite. In the county code we just adopted, as category 5 is your gift limit and category 6 is your business.
Does it really matter, though?
Well, I think it does matter, because I think it creates, it's designed to create confusion for the general public. Because I'm sitting here trying to read all this, reconcile it, and it gets more confusing as you go along.
Well,
and if we're confused here, try to enforce or implement that and try to.
But I think my point is that as long as the district, if that particular conflict of interest code is set for the people on the board that govern that district, they don't really care what Lassen High had or Ravendale had or Elm.
Well, but if we're going to administer a standardized system, which is what our role is here today. I would think it would be good if you had the rules be the same. I don't have a problem approving theirs, but I think it should be fixed so that the categories are all consistent across the platform.
Go ahead.
If I may, Mr. Chairman, the review of the districts is slightly different. How council reviews it is for legal sufficiency only. So what we look at is the California Code of Regulations, FPPC guidelines, Government Code, which is the Political Reform Act. We look at that to make sure that it's incorporating all the law it should be incorporating. As far as disclosure categories are concerned, which you addressed specifically, the FPPC does have sample or model categories. The Lassen County Code adheres strictly to those samples that the FPPC has put forward. As long as the disclosure categories have what they need to have and the proper code is being cited, and a lot of them have @sec in there, which you'll see, which means all of the following. So they've adopted that code and all the codes that follow, making their district subservient to those codes under the California Code of Regulation and the Government Code. So as long as they are adopting those codes, those are legally sufficient according to the FPPC.
Even if they scramble all the green inside?
Yes, absolutely.
Well, and I think that's the issue that I have, is that I appreciate the fact they're adopting the same code, but I think it would behoove us to make sure that it's paginated in a consistent format.
I absolutely understand your concern, and specifically what I was addressing is like Lassen County has these 6 different disclosure categories. A district could have one disclosure category and they could lump all 6 of those into one disclosure category and then say the following people are subject to disclosure category 1. They could do that if they want, and that would still be legally sufficient as long as they're adopting all the proper codes and requiring the proper disclosure.
I agree. I understand Jim's concern, but I don't think it's important because they're all separate districts. as long as we do our county as one and do the rest.
Well, let's talk about the Elmwood one, which is 8-7, because 4, 5, and 6 are together. They have categories 1 to 5. They don't even have a category 6, and they don't have any sort of reference to the gift limit. So,
But that's what that district has adopted.
but if they're required,
I think we're
yeah, but
trying to-
she's standing at the podium and telling me that they're taking the code at the state level and they're maybe packaging however they want to, and then come back and have one category at all. What I'm saying is, if you look at theirs, they've left out the gift part altogether. It's not even in their code. So, do they have to follow the gift limits of the state, or they don't?
I would think they would.
By still being required to disclose under the proper codes, and they still have to disclose that.
Okay, but it's not provided for in their resolution. It's not provided for in their document. They're required to do categories 1 through 5, and if you look through all that, every page, they're going 1 through 5, and they're not requiring their employees to disclose anything relating to gifts that would be received, board members or employees. But I'm saying is they have left that off altogether, so there's no requirement whatsoever, and they make no reference in there that they've left out that requirement of the government code in the FPPC, that they have eliminated that as a requirement expectation. They have not made any reference. It just doesn't exist.
So would you like to have you?
I would say that their resolution's defective in the sense that it does not meet the requirements of law, based on what I see here.
Okay. Mrs. Spencer, do you have a question? Make it fast, please.
I find it amusing that you just approved a deficient conflict of interest, and I agree, Elmwood's is deficient. But I just find it humorous that you just approved a totally deficient conflict of interest.
I didn't feel that the one that we approved for the county is deficient.
Obviously, you voted for
Okay.
it.
I made the motion for it.
What do I do, Jen? We gotta move on.
Well, I would say that we need to,
You don't want to Pierville Muds.
huh?
You do not want to.
Well, I think that the inconsistencies that lie across on all these, I think we need to, obviously you don't have the time to deal with it today. I'd say we continue these and properly give us a time frame where we can maybe reconcile the differences that exist between these various formats that we have. The county one's okay, but I think these others have, and I have 2, 3 other questions to ask, but obviously we're out of time. So can we continue this item to another?
Mr. Chairman, if I may, if the government code requires that if you're going to continue it, you actually need to return it to the districts with directions to each district.
Well, I'm
on how to
talking
change
about
their
us
code.
continuing it so we can come up with what kind of directions we need to give those people. Because right now, I'm not saying return it to them, I'm saying let's continue this item, our discussion, to a time when we have time to discuss it, so we can identify where those inconsistencies lie that we would like to see fixed. You can't return to them and say, well, guess what's in Chapman's line? If that's what you're doing.
That's not possible. It's not humanly possible. It's not mechanically possible. Okay.
Well, I'm glad everybody was humored by that. Because that's in essence what you're doing, and I don't think the law expects you to do that.
Well, what's the pleasure of the board? You want to continue this to another? Do we have, is there a time factor in getting these approved?
You know, if I could jump in here a little bit, is the question is the format that the districts has adopted and submitted to the county. And so we want to request that the districts utilize the same format that the county uses.
Well, that's one way you could address it, or if they use an alternative format, the format includes all the requirements of the law. And what I'm saying from just looking at the Elmwood one is they've left out one of the 6 areas that we have identified in the law that you need to report to.
And our council has determined that they don't need to include that 6th. Is that?
They are held to the code that they have adopted, which includes that.
And
Well, I don't see that in their code, though. They don't have any reference in their code about the requirement for gift disclosure.
so the question seems to be whether we are in the position of, what's the right way of putting it, substituting our judgment for theirs. And
No, I don't think we should be doing that. I think what we should be doing is identifying that their judgment is not,
Meets minimum legal requirements.
yeah, in other words, there's a format here that they've been fed, and they probably made their decision thinking they've met all the requirements of the law, and whoever gave them what they voted on, okay, may or may not have